everybody. Good morning. Meghan Maes, family law attorney, state of Minnesota. You may hear my voice is a little bit different today. I'm getting over a cold. My husband and I have 5 kiddos between us, and so we get everything. And love, of course. So welcome back to Being Civil in Minnesota. This is a place where I will give some legal information and I will give some resources because I believe that people should know what the rules are so that they can plan for their families. I really want this to be an interactive process. Hi, good morning, you guys. Thanks for coming in. And I would love if people would ask questions. I want to make sure that I am giving you the information that you are going to find helpful. Last week when we were on here, we talked just a little bit about the overview of the family court system. And someone had asked a question about substance use in the family court system. So I said that I would talk a little bit about that today. Before I do, if you want to just comment at all about what kind of information you want about substance use or questions that you have, that will help me tailor this to you. This does not make me your attorney. This is not legal advice. This is free legal information. So, one thing I'm going to do, and you tell me if this is helpful at all, is after these Saturday times that we're going to spend together, I will put this in an infographic so you can have the resource and you can share it with everybody. So the first thing I want to share with you is a resource, and it's from the Minnesota Judicial Branch website. Shout out to the Minnesota Judicial Branch website. It looks like this. It's called the Child Focused Parenting Time Guide, and it was put on by the Minnesota State Court Administrator's Office. So shout out to the court administrators out there that helped with this. There were there was a committee that put this together, and so I'd just like to say thank you to the co-chairs of the committee and all the committee members. Putting something together like this is not easy. But what it is it's a child-focused parenting time guide. And it goes through and it talks about stages of child development and things that might give a court a path to put together the best parenting time schedule or custody agreement if you guys cannot agree. So as part of this guide, there is a section that talks about alcohol and drug use issues, and so that is kind of the topic today. Drug and alcohol use can significantly impair a parent's ability to provide a safe environment and provide for the basic needs of their kiddos. And so we want to make sure that if we are having, hey Katrina, yes, you're very welcome. So if you are involved and are having to co-parent with another individual who has alcohol or drug use concerns, it is going to be very helpful to provide the court with the situation, your experience, and what is going to help enhance your life and your co-parenting journey and your ability to parent your kiddos and make sure that you know that they're safe. So another resource that I want to talk about just real quick is the Substance Abuse Mental Health Services Administration. It's a federal resource, and they talk about mental health and substance abuse issues, and it happens to be Mental Health Awareness Month, so happy Mental Health Awareness Month. Another good resource is called fasttrackermn.org, and that can help you locate a program that might be right to assess or support someone who is experiencing issues with substance use, alcohol use, or mental health. So, how does a court get a case in front of it? Well, usually it starts by one of the parents asking to establish custody and parenting time rights. And that can happen if you are a married couple and you want to do something that's called a legal separation, or if you're a married couple and you want to get a divorce and you have children together. Same with the legal separation. I'm assuming you have children together. And then the other happens when neither parents have been married before. And so in establishing custody and parenting time, again, I would like to have you know that there are resources on what custody and parenting time are on lawhelpmn.org, and there are court forms on the Minnesota Judicial Branch website with instructions that you can find to if you want to establish custody or parenting time with a kiddo. There are things in the state of Minnesota called presumptions, and a presumption means that the court is going to consider that a certain thing is presumed unless you can show otherwise. And the presumption for parenting time, which is different than custody, parenting time is the schedule and where the child is. So every Thursday at 2, the child will be with this person. That is the parenting time schedule. In the state of Minnesota, there's a presumption that each parent is going to get 25% parenting time. Most of the time that includes overnights, although the court has a lot of discretion in its power to adjust kind of what that schedule could look like. Now, I think there are some misconceptions out there about what 25% is. If we are considering just straight overnights, you're looking at 91 days, 91 overnights a year. So if you put that out on a calendar, every other weekend is not 25%, but you have to include summer, vacations, regular parenting time, and holidays. All of that will add up. The whether if you have safety concerns and you're like 25% sounds terrifying to me, the other parent is having significant issues and are just not in the right place to be parenting our kiddo, you can rebut that presumption, and that would be done by giving the court information to say, hey, I think that we may need to restrict this parenting time. The things the court can look at and things that are going to give the court information as to what the severity level and what the impact might be on the kiddo. Have there been any law enforcement related arrests or drinking and driving with kids in the car, for example? I wish I have never seen that in my career. Unfortunately, that is not the case. Has it risen to the level that family members or friends are having similar concerns? Has the child reported any concerns? Access to paraphernalia or drugs or things of that nature. I had one where it was just the sound of the ice machine and the cabinet that would make somebody think, okay, this person is going to make a drink. And if you have a similar pattern, you need to explain how you know that the person is using drugs, because sometimes the parents are not together anymore, or the parties are not together anymore. And so while you may have had information while you were living there, you may not have information today that they're currently using, but that will just sort of depend on the facts. And again, this is not legal advice, so if you have a question about that, I would totally talk to a lawyer. If there are drug and alcohol related issues, what can a court do about it? Well, the court has a lot of discretion, and they can restrict parenting time to the time, duration, location that they find is is best. And sometimes that may be a supervised visitation center. There are private pay parenting time supervisors out there that you can have access to if your community or region doesn't have a supervised visitation center. I'm very blessed that we have Keep Me Safe in Mankato, which is where I'm located, and so that is a really great resource, and so please keep in mind that that is always an option. They have their own rules and requirements as to how people will get access to those services, and there are going to be limitations as to the duration of the visit or the amount of visits per week. That would be something to address with the supervised visitation facility. You don't want to go into court and say, sure, they can have supervised visits every day from noon to 1, no problem. Well, it might be a problem if you then go to the supervised visitation center and they say, sorry, we can't accommodate that. Then what? You can also put restrictions on the use of certain substances or alcohol use during parenting time. These are called parenting time conditions, meaning parenting time would be conditioned on maintaining sobriety, following recommendations of probation, remaining law-abiding, no similar charges, things like that. If there is usually a breach of trust or a lack of trust, you can have monitoring, alcohol monitoring or drug monitoring, testing done in advance of parenting time, or if there's a reasonable suspicion that parenting time, excuse me, that the other parent is under the influence. There's lots of ways that you can ensure that these provisions are being followed. You just have to think it through what is best for you in your situation, your budget, your co-parenting schedule. There is something called like a chemical use assessment, sometimes also referred to a chemical dependency evaluation or a Rule 25. And that is an assessment of someone who may be suffering from some substance use issues. The assessment interviews the individual, and it puts forth it goes through a standard of questions, and then it puts forth recommendations for that individual. Chemical use assessments are a fabulous tool if the individual is capable of being objective about their own use. If they're still in denial, it is a self-reported process, and so they may not always have the ability to truly make a recommendation if the person is not honest at the time. There is a way to be a collateral contact. If the court is going to order a Rule 25 and you don't believe that the person is going to be truthful about their use, you could request to be a collateral contact, and that would mean that you could provide the additional information to help the evaluator assess what might be the best. Can't believe nobody has any questions yet. What's up, guys? So the other thing you can do is just limit the parenting time. And a lot of questions I get are, well, what happens if they don't? What happens if they don't follow through? How long do I have to continue to do this? How long do I have to continue to bring my children to a visit where they are disappointed or I'm the bad guy? Courts have the ability to put parameters on. Oh, hey, Lindsay. Hi, Jay. Thank you for your questions. The court has the ability to say, for example, 3 strikes and you're out. If you test positive 3 times, then your parenting time is going to be suspended until either the parties agree or you come back to court and you show the court what have you done to demonstrate your commitment to being the best parent you can be for the kiddo. All right, so Lindsay says, if I think the other parent is under the influence, can I withhold sending my kid with them at the time? I agree. That's a great question. So it depends on whether or not you have a court order. Okay, so if you have a court order that says Chris spends time with the other parent Thursday at noon, and you go and Thursday at noon you show up to the police station to meet, and their car is parked crooked, the eyes are watery, they smell like vodka or weed or whatever it is, they're technically the correct way to address this would be to file a motion with the court to suspend the parenting time. If you do withhold the child and it turns out that the other parent was not under the influence, they could be entitled to compensatory parenting time. Now, I know I'm still kind of not answering your question, and that is because if you violate a court order, there is a process called contempt. And that means that if you are brought in front of a judge, you are going to have to tell the judge why you did not comply with that court order. And the judge has lots of discretion to determine whether or not your non-compliance with that order is reasonable. I think that if I'm a parent and I think the other parent is under the influence and they're going to be I'm not putting my kid in that car. I think, but I think you also have to be prepared for what is the next steps. If you deny parenting time, I'm hoping that your court order has kind of the parameters that gives you the ability, Lindsay, to make that decision at that time for your child. And if you don't have that authority in your order, you should really consider whether or not you might need different kind of provisions. Because who are you going to call at this point? My guess is that you're not going to call the judge. My guess is that you would call law enforcement. There is law enforcement, their job is to protect and to serve, and there is a way in a court order to say, I would like law enforcement's help enforcing parenting time. So if your exchanges are already at the law enforcement station and your concern is alcohol, well, maybe they could take a PBT. Now, will the law enforcement officers do the PBT? No, I'm certainly not trying to say that this is where the cases go, but most people go to the law enforcement at this point. The issue with doing that is law enforcement is very limited in what they can do. They cannot make decisions in these situations. Typically, law enforcement comes in and they will try to stabilize the situation to make sure that people are safe. Jay asked a question, when is it an appropriate time to be a collateral witness? Well, I think just going back to what a Rule 25 or a chemical dependency assessment is if you believe that the other person is struggling, they can take this assessment. If you don't think they're going to be truthful, you can ask to be a collateral witness. If you don't think that they can objectively say, yes, I'm struggling, I'm consuming this amount, and they're not going to be honest, then I think being a collateral contact would be very appropriate. Most of the time, the individual doing the chemical assessment may not voluntarily say, sure, come on in. You may have to ask the court order a chemical dependency assessment, and then you can ask to be a collateral contact, and then ask for a copy of the recommendations, and that they have to comply with the recommendations. Rachel asked what kinds of things and questions are asked within the assessment. Now, I already disclaimed that this is not legal advice. I also need to disclaim that I am not a chemical or alcohol and drug counselor. I don't have any kind of credentials in that. However, I've seen enough of them to say that they are going to ask about your environment, your past use, your current use, and things that are impacting or might be barriers to you getting the resources or help or appropriate treatment that you might need. Katerina asked a question. In her current court order, there's no repercussions if he doesn't do a hair follicle test. He has to do so in order, to get to phase 2. At what point can I go back to say, hey, wait, we're still on phase 1 and it's been months? Well, there is a way to modify custody and parenting time, and this might be a good segue into that. So when you talk about establishing custody and parenting time, there really are things that the court looks at. They look at the best interest factors, and there are 12 of those, and honestly, I could spend a whole Saturday morning on those. But one of the more important ones for this is the physical health, the mental health, and the chemical health of the parents. If there is a parent that is struggling with substance use actively and you have current concerns, there are ways that you can go back and modify your current court order. Now, there are limits on that because the court doesn't want us coming back and forth all the time. So what might that look like? If you want to modify custody or parenting time, there has to be a present, a right now concern for the kiddo's safety. And they define that as likely to endanger the child's physical or emotional health or impair a child's development. So if there are behaviors or traits that are happening due to substance use or alcohol abuse or mental health concerns, and they are interfering with your kiddo, like maybe they're not showing up, maybe they're not showing up sober, maybe they're not doing the things that you gave them the opportunity to expand their parenting time. If it's a persistent and unreasonable, the second way to modify custody is where one parent chronically or unreasonably fails to comply with court-ordered parenting time. Depending on how long you've been on phase 1 or what the plan is, it may be chronic. It may be unreasonable to not want to get to the next step and to expect a family to continue to live in sort of a uncertainty where they can't count on the other parent or the parenting time schedule, because I constantly see parents who are out there struggling because so-and-so didn't show up to parenting time, and then they have to go look their kiddos in the face and say, sorry. What other questions do you guys have? I mean, these are really good questions. I did want to talk a little bit about the difference. There's a difference between custody and parenting time, and I did briefly talk about parenting time for most of this, but there is something related to this called legal custody, and that is decision-making ability between you and the other co-parent. And in Minnesota, there's a presumption that you and the other co-parent are going to make those decisions for your kiddos together. How do you rebut that presumption? You can show that you're not capable of co-parenting, and some of that inability to co-parent may be the other parent's diminished capacity due to perhaps substance use, chemical use. And I'm not out here trying to shame people who have gone through their process. I want to, you've heard of downward spirals, right? I love representing clients on an upward spiral. So I want to give hope to those who may be in active recovery and want to get back involved with their kiddo because, they've done the work and they want to, and power to you for real. So there's something a court can do if you are one of those parents who is struggling. A court can reserve, meaning they will put it aside for now, a future increase or expansion of parenting time. So what Katerina was saying about phase 2, that's called a graduated parenting time schedule, and it typically involves more restrictions in the beginning, and as time goes on and steps are made and sobriety is maintained and trust is rebuilt, then that typically will expand. So make sure that if you are that parent, you are asking for that path forward. The courts do not want to penalize necessarily parents who have, doing their best as an imperfect human, have made mistakes and are, wanting to just get back out there and really, take ownership of that. I unfortunately had a hearing recently where it was alleged that perhaps because a person was seeking treatment, that meant that they were really, really bad. And I disagree with that. I think anybody who is out there getting the services they need, I love that. I love that, and I will just continue to throw myself in front of that nonsense in the court, because I would much rather have somebody that is out there, doing the best they can, getting the resources they need, than somebody who's like, I don't have a problem. I think that's a lot for today. I don't want to, have these be too long because I want them to be informative. If you have ideas or additional questions or ideas for other topics that we could cover, we haven't even talked about what the steps are to modify or to establish. We can certainly talk about things like that. If you do have questions, go ahead and post them on this video if you weren't able to jump in live. Thanks everybody who's here. Take care, and I will see you guys next week, Saturday at 10. Bye.